All right, so we're ready for the fourth panel, and to follow Professor Craig's wonderful chairing, I'm proud to call on Professor Ikechi Mbioji, also one of Osgoode's very own, to kick off the next session.
Obviously, we've been enjoying a massive feast, an intellectual feast, so we shall continue. To my immediate right, of course, is Tanya Woods. Obviously, you must have her profile with you in the package. And next to her is Eric Baptiste. And then, of course, all of you are very much welcome. We shall start off with Tanya, not just because she's a lady, but because she's right by my immediate right. So there's a kind of bias to those who are sitting very close to me. So Tanya.
Great. I'm going to go that way.
Good, good.
I hope you don't mind. So I got free reign. Professor Naban said I can do whatever I want. And I thought, great. Where am I going to start? And I work in practice. I'm copyright counsel for Bell, for all of Bell. So it's quite a big job to start turning your mind to things like UGC, because we're many different things as a company. So I'm going to try and provide very practical, bear with me here, very practical thoughts on this, how I think of things every day. But I'm going to lay a bit of groundwork. So what is UGC? I'll offer you some thoughts on that. I'll explain to you who is BCE, for those that may not know. I'm going to talk to you about the relationship between Bell, or BCE, Bell, and UGC, and then tricks and tips, which I've now sort of compressed into a big caution sign of things to think about as you move through. Great. So UGC, we didn't invent it in Canada, although we made it part of our law first. But it was a topic a while ago, particularly at the OECD. So I wanted to share with you some ideas. What is UGC? And when you take a look at some of the things here, there's very broad definitions and more narrow definitions. So for example, the OECD said, well, users draw on new internet applications to express themselves through UGC. So that's an idea, okay. So they're talking about the internet. But then I took a look at Wikipedia, and I thought, of course, because you always have to look at Wikipedia. And I inspired myself a little bit about, what was Wikipedia thinking. And they said new technologies that are accessible and affordable to the general public, all right. And it includes everything. Blogs, social networking, wikis, mobile, photos and such. And there's different licensing conditions, okay. But they also did note that it includes news. And we might not think of news. So then I thought, well, the OECD must know exactly what this is, so I'm going to rely on them, and I'm sure the Canadian government also would have relied on them. And so I pulled up the 3 criteria. It's content made publicly available over the internet, which reflects a certain amount of creative effort, and which is created outside of professional routines and practices. Okay, so what did we say? Well, we didn't quite say the same thing. Certain things are reflected, so we have create a new work in which copyright subsists, so that imports ideas of originality, as we talked about before. Done solely for non-commercial purposes, okay, also reflecting. If it is reasonable in the circumstances to do so, that's sort of gray, but okay. And does not have a substantial adverse effect or potential impact on the exploitation, and it can't be a substitute. But it didn't say it had to be digital. And I thought that's really interesting, because we think about it that way. The government thought about it that way when they talked about video clips and mashups and posting and remixes and stuff like that. But it doesn't really say that. So UGC in Canada, I think, is definitely more than just digital. It's more than online. So this is my starting point. So who do I work for? Who's the company that's I'm thinking for right now? And I'm thinking for BCE. And who is BCE? So for those that don't know, BCE is a massive distributor. We are also an intermediary, and we're also a content broadcaster and creator. So we have a very big range. The numbers are there. We have 7.8 million wireless subscribers. That's interesting when a lot of UGC is happening on mobile devices. internet. We have 3 million internet subscribers. Well, we're an intermediary, for sure. There's no doubt there. Also interesting. Home phone and UGC, I don't think there's quite a fit. Bell TV. Well, the more that mobile TV and smart TVs are evolving, UGC plays a role. So that's an interesting space you might not think of automatically, but it definitely exists. And then, of course, Bell Media. And for those that don't know Bell Media, just to go back quickly, you might recognize some of the brands: CTV, BNN, Much, RDS, The Loop, as well as all of the radio properties that we have. So we have 107 radio properties. And of course, there are fans on these properties who want to engage us and engage content. We have 34 specialty channels, 4 pay services, 1 pay-per-view service, and 30 conventional TV stations. So you get a sense. I was approached recently when I was at another conference, and someone said, so you're kind of like Comcast and Universal will be soon. And I said, yeah. And he said, oh, we should talk. And I thought, no, not happening. Anyway, so Bell and UGC. So we know about Bell, we know about UGC, sort of, and this is Bell Media's mission. And when I was looking through our company documentation, I thought, this struck me. The word engage popped out of the mission. And I thought, well, that's right, because for us, UGC, that our fans and our viewers engage in with respect to what we do, that's engagement, and there's UGC, that's important to us. So I thought, right, where do we engage? Well, Bell Media, we know, engages on Twitter and Facebook, and I'll show you some examples of that in a minute. So I stepped back for a second. I thought, okay, how am I going to develop a position to tell people what Bell thinks about UGC? And I thought, I better lay it out very clearly so you understand the facets that we work around. Copyright owner. We are a copyright owner. We produce content. We create content. A lot of the content, though, includes other copyright protected content that we clear for our use, but we don't necessarily clear it for your use or other third-party uses. So I'm slowly going to start putting up some fences so that you understand that we can't just say go for it. It's not actually possible. Copyright user, well, this goes to sort of the point I just mentioned. We're licensee and distributor. We're largely a licensee. We may be exclusive or non-exclusive, but we don't own copyright in everything that we distribute or broadcast. We simply don't. So we have to respect the contracts that we enter into with other content producers. So that's the sort of behind the arrows, an old scroll, but in my mind it kind of represents the very long, complicated contracts that we enter into. And those contracts certainly put shackles around what we can do. It's not just free. They don't say, here, you go. We want you to engage with your customers, go. Encourage them to make UGC. You make UGC, go. No, it's quite contrary to that, actually. And then I thought, well, we're an intermediary. So this is interesting, too, because we're the ISP. We're your mobile provider. Do we have an obligation to enforce copyright? I'm not going to dive into that too far because we'd be here for days and it's another dispute and we'll just move along. But nevertheless, we do have obligations as an intermediary under the Act relating to hosting content that could be infringing, and of course, forwarding notices on from copyright owners who don't like things that are posted online. So we're not totally free, but nevertheless, I came up with a UGC set of objectives. And number one, naturally, this is going to be quite logical for most of you, it's to respect our legal obligations. That's number one. And number two, engage our viewers. So how have we been doing that? And these are some examples. So I'd like to show you a video about an app that we produced, Make It Epic. It came out around the time of the 2012 Olympics, and I had to clear the music for Chariots of Fire. And it was so complicated. I had consultants trying to help who were experts in clearance. I had ended up with a call at 7 o'clock on a Saturday with somebody at EMI Publishing in New York, as well as a few others. And they said, well, what do you want to do? And I said, I don't want to do anything, but offer an app to our viewers to create content. So this is what the app looks like. Now I wonder if I can, I don't know what else you'll see if I click on it, but let's see. It'll just explain it. Maybe not. Maybe I'm not connected to the internet. Maybe I am. Okay, this is promising. Brought to you by the sponsor. Sorry, can't skip it. Got in any case. Well, I think we'll skip it because it's 1:40 of not what I want to talk about. So let's move along. We'll go back to this. But the short is, for those of you that haven't downloaded the app, there we go. It's basically an app that you can make a video, okay? And so if I decided I was going to capture the panel, I would capture them doing whatever. Maybe Eric is going to jump, and the others are going to watch in awe of his jumping. Exactly. And it will slow it right down and then play Chariots of Fire. So it's to make your Olympic moment. Pretty funny stuff has come out of this. So it was our attempt to facilitate UGC, but we had to be very careful, and we still had to clear rights, which took time. Then we've got news. So news is another place where we have a lot of UGC, but it's not really based on pre-existing works. So we often will get Twitter exchanges. So if something happens, there's an accident on the highway, and it's quite bad, a news reporter may tweet the accident, but a viewer may tweet it before the reporter. So we rely on users to generate content and share it with us. It's a little bit different than those users taking content and it was our content and reworking it and pushing it out. So there's an interesting exchange there, but I wanted to highlight the exchange. And then the last one is a really neat one. So there was a guy, he was called Mr. Log or Log 1021. And he was a huge fan of TSN. And he basically took a bunch of clips from TSN shows. Now, we own the copyrights in TSN. And put them all together and made sort of his top 10. Kind of like what you do, not quite as what you do, but kind of, sort of, right? A little bit of remixing, mashing up, whatever. He was really popular, but he was infringing copyright. So what did we do? Well, I don't know if you can read it. We hired him, actually, after we pulled down his content. There was a funeral for the loss of his YouTube channel. It was a big deal. Like, we got a lot of attention on this, but he was really, really good. And we hired him. I'm going to come back to him. I want you to keep him in mind because he brings up interesting questions. So things to keep in mind before we get to him. Commercial purpose, I don't want to belabor it because we've already talked a lot about it. It's a terrible, terrible term to use without definition. To give you an example, Creative Commons. So how many people know what Creative Commons is in the room? Okay, enough there. I'm not going to explain it. Anyway, they have a non-commercial license, as you would know if you know what Creative Commons is. They actually undertook a study in 2008 to define non-commercial because it was so problematic for people. I don't believe, when I looked last, it was actually very conclusive, but it did tell me there was a range of ideas for non-commercial, and I made a note because there was a tweet, and I really liked the tweet from @JenRPeters, who said, how do you measure success? And here I think she was really asking, but she'll correct me on Twitter, I'm sure, how on earth would we figure out commercial purpose? And it's not that easy. So in some things I've read, it says, well, because there's an exchange of money. So certainly our DJ Lance Romance, like, he's making money, so we've heard the reactions about that, okay? But what about our guy, our TSN Top 10? He didn't make money, but we hired him, then he made money. So when we hired him, should we have changed, like, would this have still applied if he made his UGC for that purpose and he tried to use Section 2921? I don't know. I don't think it would apply because I'd argue it wouldn't. But nevertheless, it's very gray and it's problematic. I think MIT says that it's based on the use itself, whereas there's another academic institution that says it's based on the user. And another person says even the thought that you could make money means it's commercial. Well, God help us to figure that one out. I don't know. So just clear your rights. But terms and conditions. So we're going to move forward. Be mindful of the platforms and technologies used when creating UGC. Now, this is for me as a company. This is for you as a creator. This is for users. That sort of, yield sign isn't just for nobody. It's actually for everybody, because when you use Instagram or when you use Facebook, there are terms and conditions on those sites. And I'm going to show you at the end of my presentation Star Wars, because he's not, the best guy ever, but we'll get to him. In any case, you've got to be careful, because if you really are a creator and you want to use Instagram, for example, and it's not fair to use Instagram, but it's at top of mind. I haven't read their terms lately. But I want to keep full control over my stuff. If it says in the terms of use that I am giving a non-exclusive, worldwide, perpetual, yada, yada, yada license, that means I don't get to keep control of my use. You need to know that. That's important. The inevitable bad UGC. Okay, let's talk about bad UGC. Can you read this flow? So Drake is spokesperson that we're very, very pumped about for basketball in this city, for a team we have a stake in. But it says, what a joke. This guy is useless. And then it says Rob Ford has more street cred than him. Ouch. But that's UGC, right? So this is on the TSN Facebook page. We know we're going to have that kind of engagement. But this engagement isn't bad. We don't mind it, because then what do we know? We know, maybe these guys aren't fans. You could figure that one out potentially quickly. But if there's, a million people saying the same thing, maybe we made a bad choice. It's not always bad to have bad feedback, but you have to know it's a risk, and you have to be willing to mitigate the risk. And I think there was some points made on that earlier. Respect rights, engage responsibly. So this is more a corporate consideration, but I think it, again, would apply for everybody. But if you're inviting third-party users to create UGC, and let's say we've got the case of my Make It Epic app, I really need to make sure I protect them. Because it may go commercial, it may not go commercial, but I think it's my job as a very responsible lawyer to try and make sure I've got their uses covered off. And I'll pay for them, trust me, I'll pay for them, but we've got to be cautious about it. Also, if it's possible, offer guidelines. So as a company, I can still offer guidelines to my users, and they can make sense. The law, it's not great. We know that. We've already talked about that. But I don't necessarily want to invite them being my users, my viewers, my consumers, to be offside the law. I want to help them out. So I think this is an important one. But also protect your IP clearly. So 4 kind of flows into 5 with user-friendly language. Let's look at Star Wars quickly. So terms of use, green is good, orangish yellow is and red is not the greatest. So green says Lucasfilms does not claim any ownership rights in user-generated content. Good. They don't want a piece of anything, really. But then they say you are going to give them about as big of a license as they could come up with, and they can probably do whatever they want with it, and they're not going to pay you. Okay, well, I'm like less happy about it now. And then they say, but you're responsible for making sure that you have all rights in your content, including the rights necessary for you to grant the foregoing license to your content. You know what that means? That you cleared everything you used. How is that friendly? That's not friendly, come on. Okay, so my very practical tip, and my last one, is cooperate with partners. So Google Content ID, initially the panel was set up that someone from Google might be joining us, so I built in the segue to them, but the link is there. I'm happy to post it up if you want to learn about Content ID, but it's a great way to sort of work with partners. So Bell Media could work with Google Content ID to take care of its copyright in the online space and make a decision about how it wants to enforce its rights or not. And I think it's really important in this space to cooperate with partners. That's it. Thanks.
We'll go on now to Baptiste. Thank you very much.
Thank you very much. Thank you very much. Can you hear me? Yes? Okay, thank you very much. So I don't dance very well. Sorry, Tanya, and I'm not a lawyer either. So I use that sentence very often, but here I'm not sure it's the right way to begin my intervention. But nevertheless, I'm not a lawyer, so I'll try to focus on the experience SOCAN has had recently with YouTube, which is as far as music is concerned and nearly everything, the most important user-generated service that is around. And first, a few words about SOCAN and about me. I'm the CEO of SOCAN, and SOCAN is the Canadian Performing Rights Society, so the society that looks after the rights of authors, composers, and publishers of music. We represent about 117,000 direct members, people who are mostly in Canada, coast to coast. And we also indirectly represent about 3 million, 4 million, we're not completely sure, because of the databases around the world. We represent millions of foreign writers, composers, and publishers who have given a mandate similar to ours to societies around the world. And we license many establishments. We license about 125,000 establishments in Canada. Many big companies like the media properties in the BCE group, very important licensees for us. We also license shops and restaurants. And we recently have, a few years ago, started licensing digital and internet services. And today, focusing on user-generated content. So our business model is, in principle, fairly simple. We have the rights to license, generally speaking, all the music that has been created, written, published in the world. And we license on a blanket basis. That is, once we grant a license, for example, to CTV, CTV is free to use, or is able rather to use all the music that has been published and created around the world for a fee. They don't get to pay us more for a Beatles song versus a Nickelback song or whatever. It's blanket. It's very simple. It's a one-stop shopping system. What is a bit less simple is first making sure that we can value that license at the right amount. How much is a license from SOCAN worth to CTV? It's not simple, but we can rely on decades of history, decades of experience, both here and around the world. So there are lots of benchmarks and milestones to rely on. And there is also, especially here in Canada, a principle, a system that provides for the intervention of a quasi-judicial body, the Copyright Board, that certifies what we call tariffs, or they could be called conditions for the licensees. SOCAN could, and sometimes does, enter into negotiated licenses with users, but the legislation here in Canada, for what I understand, you're the legal minds here, provides that we have to go to the Copyright Board even after we concluded an agreement once the tariff applies to more than one user. So if it applies to a class of users. So we couldn't have an agreement with just CTV because other broadcast channels are in that class and we need to go to the Copyright Board. It's a system that is fairly unique to our country. It provides quite a few benefits, especially the transparency, the fact that those tariffs are debated. We provide our facts, our arguments, our justifications for the value we want to assign to a given license. Our friends, the licensees, usually explain why they think the value is a bit less than we like to believe. And the Copyright Board issues a decision that is increasingly, unfortunately, subject to judicial review. So sometimes we have to wait until a few years have elapsed to know whether or not the license conditions, the tariff conditions will be valid, or if the tariff is going to be valid at all. And we had, for example, last year, a very bad experience about the tariff we got from the Copyright Board quite a while ago for downloads of music. The Supreme Court of Canada, many of you will remember, decided last year that the people we represent, the songwriters, composers, and publishers, couldn't license download sites for performing rights. So a process that is well known, that is transparent, that is public, that has its pros and cons, but something that applies very well to established cases. established business models. I'll come back to that in a few seconds. The other difficult part in our business is once we have licensed the business using the music, I'm still going to use the example of CTV, and CTV can draw from our repertoire whatever music they want to use in their programming. We have to make sure that we know exactly what are the works, the songs that have been used by CTV at every moment, and then decide how much each of our members is entitled to get from the royalties that CTV is paying us. So we have to match the use with the license fee amount, verify that if your song has been played 10 times more than your song, you will get 10 times more money. So there's a lot of processing involved, a lot of checking, and a lot of IT systems involved. But we're not going to deal with that today. But I wanted you to make sure I wanted you to understand that the blanket licensing system is kind of easy for the licensees, but it requires a lot of work on our side to make sure that the right songwriters, publishers, and composers get the right amount of money. And since we represent millions of people who are not from here, it's also an added layer of complexity to make sure that we are informed in real time of music that is being created in Australia, in Germany, or in Brazil. But enough said about our traditional business model. We have been trying to make sure that all the uses of music are licensed in Canada. We want to welcome business models as quickly as possible, but we also want to make sure that we license those uses at the right level. Our mission is to ensure our writers, composers, and publishers that the licenses have the right value for the music that they represent. It's a lot of talent, it's a lot of hard work. It's not something that happens in your sleep. In order to compose music, to write songs, you need to work. Not all of us can do this, and I certainly couldn't. But those who can have to work a lot, and I see one or two in the room here, so I know they understand what I mean. So YouTube, we've been exploring, and we've been successful so far, the agreement route. Not waiting for the full process in front of the copyright board to run its course. We decided to explore with YouTube for Canada the idea of an experimental agreement. That is an agreement that, because YouTube is the biggest user-generated content site, but it's not the only one, will have to go and is going to the Copyright Board of Canada, but could be concluded without prejudice, without binding the parties for the future. So we have been able to reach such an agreement at the end of last year, and it's valid for the years 2007 to 2013. And the issues that we had when meeting with our colleagues at YouTube was on which term to base the license. How do you value the use of music in something that is so radically new as YouTube compared to a linear TV network, compared to a radio station, compared to a restaurant, compared to a shop? And it doesn't help that the agreements that YouTube and other sites like that have concluded around the world are subject to non-disclosure agreements. So nobody can rely on international precedents very firmly to decide the value of the license in a specific country like Canada. We can't go to the UK or to the US or to France to verify what our colleagues in other societies have agreed to with YouTube and adapt that, taking into account the Canadian context. We have some ideas, but they're not more valid than yours, because our colleagues cannot tell us. So the questions we asked ourselves were, how do you measure the colossal amount of music that is available on YouTube? You have billions of clips, of extracts, of audiovisual content that include music. How do you value that compared to a linear TV station with 24 hours in a day? How do you measure with precision and assign value to the different kinds of music you find on YouTube? There is the official content, the things coming from for example, the record labels. But you also have clips that have been illustrated with music that is commercial music, but dancing babies or cats falling in the toilet bowl, or all those things that have made YouTube such a fantastic thing to watch. You also have amateur performances of very well-known works. You have music that is associated to full-length movies or clips of those movies or trailers or TV series, all those things. So how do you measure the value of that music? Which metrics do you use? We can continue. Not only do we have many cases for the use of music, but there's also a lot of different economic values for YouTube. Some clips are accompanied by commercial advertisement on the side. Some are not. Some are part of commercially available movies or trailers. Some are purely amateurish things. So another layer of complexity. And we decided after a long discussion with YouTube, to take a fairly simple approach, illustrating the fact that when you have a willing licensee and a willing licensor, and SOCAN is trying its best to accommodate the new business models within the rights of members and the willingness to pay, we decided to take a very simple approach, that is to use the rate that commercial TV pays for our licenses. So this agreement is based on the rate of 1.9% of commercial networks, but it is a bit lower than we would have expected because music is so important on YouTube. It's one of the main appeals. We would have expected, we would have hoped a higher rate, but we decided to try to broaden the base. And the license covers the tariff, the agreement covers all YouTube content, not just the one that is linked to music. So the base is a bit broader than in usual negotiations on tariff in exchange for a rate that is not as high as we would have liked. So as I said, this agreement is experimental. We expect to have another one for the future. It's not the best we could imagine, but it works for us. It upholds the value of the rights we represent, and it enables YouTube to be legally operating, as far as we're concerned, in Canada. A few words, because I don't want to be too long, about the user-generated exception. It has not impacted our negotiation with YouTube, first because the act was not in force at the time, and also because our agreement doesn't distinguish between the use of music or the use of other content. The rate applies to views from a Canadian IP address. But nevertheless, as we heard just before, and I'm sure this morning as well, this user-generated exception here in Canada is unique. Doesn't exist anywhere in the world, to the best of my knowledge. We don't believe it was necessary. We were able to reach an agreement with YouTube before the current Copyright Act was in force. It's creating lots of complexity, and Tanya explained very, very well from a media company's perspective how some elements will have to be clarified, have to be resolved in order to have certainty. So we think it's not helpful, we think it's not useful, it doesn't help the creators of content, it doesn't really help anyone in this business, and we regret the fact that it was included. And once again, it's unique. And whenever I go to international meetings, my colleagues ask me, what about this user-generated exception? And I'm at a loss to explain why it was necessary and what it does exactly. Thank you very much.
Thank you very much.
Hi there, my name is Umi McDonald. I'm here from LegitMix. We're a startup based out of Ottawa with people in New York City as well. So how did I get into LegitMix? I'm a software programmer who's done startups in different spaces, like in medical and in telecom. And the way I got into LegitMix, is, get some power here first. The way I got into Legit Mix was through my best childhood friend, who after completing McGill went to New York City to work for 4 years on a documentary on hip-hop artists in Queensbridge, New York. And he got some traction for his doc. It was accepted in the Slam Dance, and a distributor came to him and said, "I'd like to distribute your movie." And they told him he has to clear the music. And he was like, well, what's that? So after 9 frustrating months of learning the whole rigmarole with music licensing, and the bill for one of the songs in his movie at $300,000, it killed his movie. And his movie was never released in its original form. It was released through Fuse by essentially copycat music, and it destroyed the integrity of his film, and he can't even bear to watch it. So we were talking about we met up one day, and he told me about this problem. And he educated me about this whole issue of music licensing, remix, and this whole world, which we've been educated quite a bit about here in the context of user-generated content. I'm not going to go into this because Daniel does such an amazing job on describing what is remix, but digital technology has enabled huge art forms to flourish. And now this was also happening before the advent of digital, as people have pointed out. Hip-hop is a sample-based remix genre, where back in the day they did it with tapes, and now with tools, millions of people can now do this in their bedroom. So it's really taking existing art and to create new pieces of work, be it sampling, remix, mashup, mixing, as Daniel's excellent presentation covered. And what, I don't know if the importance of this art form is really sunken in, but it is the music of the digital age. Everyone here knows Harlem Shake? Amazing, all right. Harlem Shake, a bootleg. It's a mashup, a sample-based work that contains 2 unlicensed samples put out by a DJ named Bauer and his label Mad Decent, who's now in a whole bunch of litigation around that track. So the #1 track of 2013 is a bootleg. Everyone knows people aren't going to see rock bands anymore in stadiums, they're going to see their DJs. Astonishingly, the top 10 DJs last year earned $125 million for spinning records. There's over 20,000 full-time DJs. These are people who make their living off DJing in the United States. And this is a mainstream practice. But the problem is the current music licensing system wasn't designed for remix, wasn't designed for such a huge volume of, call it, derivative content. And as we briefly touched on before, and I'm talking from the US context, our focus is the US market, because it's the largest music market. But in the United States, if you want to distribute, I'm not even talking about selling, but just even to distribute a derivative work, you have to get licenses from both the publisher and the record label. And that's a very difficult process, as my friend found out. First of all, someone mentioned, well, it doesn't cost to ask. Well, actually, it does cost to ask. We tried to license a Chromeo track for our own corporate video, and we spent weeks even trying to find out who to talk to. So it is a very expensive and time-consuming task, and there's no standards. There is no statutory licensing framework for remix. I could make a cover, and the United States and Canada has the same notion, and it's defined what I have to pay the original artist to make a cover. I don't have to get any permission, I don't have to do anything, I just fill out a form and pay the money. Congress sets the rates. There's no such thing for remix. It's a manual negotiation for each rights holder. In the case of my friend's song, he sampled, his movie had the Dog Pound in it, which had like 7 samples down. You have to clear it with all the parties. So it's a mess. So what's the upshot of that is the vast majority of remixes, mashups, DJ sets, what have you, are never cleared for legal distribution. And we view this as a huge lost opportunity for both remixers and original copyright holders, where they're getting nothing, and the people who are hosting these derivatives are getting revenue through different means. And the fans can't buy what they want, so if you're in the nightclub and you just hear the most awesome remix, most likely it's a bootleg, you can't buy it. You can't go show support for artists. It's breaking that bond between the consumer and the artist, because the consumer can't buy the music they love, which is just nuts. And it's creating this huge cultural divide. We felt it a bit today here. Daniel got it between the eyes. is creating this divide between two sets of artists, which there should not be. The other problem with remix is that it's challenging for the copyright holders to police and enforce their rights. We just heard about how YouTube and their Content ID system, well, Content ID cannot reliably detect sample-based music. The technology is not there to reliably do it. And then the moment you get into that, YouTube doesn't want to touch it because then there's a whole fair use argument, and they've already been slapped on the wrist for taking down works which may qualify for a fair use exemption. So it's a mess. So when my friend told me about this problem, I thought of it as a software engineer. I'm a software guy. And for me, it's very natural for me to build on top of other people's software. I write software that runs on Microsoft Windows. I don't have to license Microsoft Windows to do that. I don't have to talk to anybody. I just do it. And the person who wants to run my software has to buy and own Microsoft Windows. So I said, well, the problem with Remix is that the remixer's intellectual property is glued in with the music they sample. So I said, well, what if you could separate that? So separate it and think of it as an instruction set, which could then be sold or distributed to a consumer, and that consumer, using their copy of the original music, can recreate Daniel's work or what have you. So this essentially creates a new distribution channel for this type of work in a way that encourages the purchase of the original music, because you have to buy it to enjoy the next layer on. So how to do that? And when I first started, I sat down and I struggled with the problem. I thought about language to capture remix, and then just finally hit me, subtract. So we do a very simple thing. We take the original, we take the derivative, and we subtract. But we do that subtraction in a binary space. And this strikes it odd to a lot of people who think about music, well, how do you remove the music and so on? Well, we just do it in a binary space. And at the end of that subtraction, you have a file which is nothing. It's not music, can't be used to make music on its own, but a consumer can take that, their copy of the original tracks, and recreate the derivative work for their personal use. So that's the, and how it works. Just one point on this one. This is all predicated on the notion, and what I assume seemed natural to me, is that a consumer can remix music they own. So, but that seems natural to everyone. I don't know if that seems natural to everyone in this room, that I could buy a track and remix it at home for my personal use. But there are, I was in LA 2 months ago with at Universal Publishing, had their whole 12-person legal team in front of me, and they said, well, no, you can't remix music at you own, period. And then we evolved and discussed it, and luckily they would concede that is the personal space and the personal use is one they don't want to get into. So what's the workflow? So Daniel, and we actually just did this earlier. I don't know if I'll have time to get into the demo. Daniel goes to our site and says, okay, these are the copyrighted tracks I use. So it starts with Daniel. He actively protects the original copyright holders that he samples by identifying them in the process. Starts with Daniel. Says, okay, I sampled Stevie Wonder and so on. We create the legit mix file. So the legit mix file is now up in the cloud. A consumer comes around, installs our software, and they have the option of having our software check their computer to see if they have the tracks Daniel sampled. If they don't, we send them to iTunes to purchase it. And also we've reached deals with 3 of the 4 majors to sell the music directly to them as well. But right now we're using iTunes. If you don't have the tracks, you buy them from iTunes, getting the original artist paid, but more importantly, preserving their legacy. Right now, when you do a traditional sample clearance, you may get a little note in some liner somewhere and some payment, hopefully, that your work has been sampled. But with Legitmix, you get to own that original track in its entirety, in its original form, and grow your fan base through the remixer. I was at a meeting with the gentleman at EMI who manages the entire back catalog of EMI. You know that 90% of the revenue, of the profit of EMI comes from back catalog. They make nothing from Katy Perry. That's all the back catalog, which the stuff has been paid, and it's pure profit when someone buys that track. He said to me, this is genius. This is going to turn every DJ into a salesperson for my back catalog. Because that's what DJs do. They take old music, make it cool again, recontextualize it for a current circumstance and for people's enjoyment today. And so now they're enabling, essentially the labels now have millions of new people selling their catalogs. So the business model is extremely straightforward, and we're talking about transparency, very transparent. You want to buy Sabo's Thriller Remix? Great one for Halloween. I suggest you go to legitmix.com and get a copy. So he did a great remix of Thriller. So you pay $1 for his Legitmix file. 70% of that goes to Sabo. 30% goes to Legitmix to run the show. And then you send $1.29 to iTunes, which portion of it will make it to the original artists and publishers. Very simple. It's very simple, very transparent. So we've been at this. We opened up the site just about a year ago, and we've been. I've been invited to other copyright forums in the United States, and people are truly intrigued with this idea, in a way that it's automating a very manual process that exists today. Time Out New York actually highlighted this as the coolest startup in New York this year, which, since we only have one person in New York, I thought that was a bit of a stretch, but why not? So I'm going to try to do a demo if the technology gods will align to do it. But so we have, since launching, opening the site to people to post about 10 months ago, we have 2,000 remixers using the platform, and I'm just going to highlight some examples out of them. For example, DJ Earworm. Anyone hear of Earworm before? United States, about one person. Anyway, on January 1st, you should definitely tune in to hear what he does. Is he does a mashup of the year's top 25 hits, or 20 in that range. So these things get, I think it's up to 150 million views on YouTube. Not a dime goes to the original copyright holders in that scenario, because they can't detect the original tracks in it. He makes no money because he can't. He doesn't want to bootleg his content, so no one's making money. Well, YouTube's making money because they run ads against it, of course. So he's now made his entire catalog of 500 mashups available through Legitmix. I'm really looking forward to see what's going to happen with the one coming up. But he did a smaller mashup, which got like 1 million views on YouTube. He sold 300 copies of his $14 package, so you have to buy 10 tracks and then buy his Legitmix file. So it's a 10-to-1 ratio. And for every $1 he makes $10 for other artists. It's a win-win for everybody. District 78, these guys are remixers on, anyone watch So You Think You Could Dance? No? Anyway, so they do the remixes for that show. Diplo, I imagine people have heard Diplo. He's done projects through us as well. We have cheermix DJs. These are people who take 5, 6 songs and make mashups for cheerleaders. Right? Before, they used to pirate. Now, it sounds crazy, but there are millions of cheerleaders in the United States, and they have no mechanism to license the music. It's impossible to try to get 10 licenses to the biggest tracks, and right now it's all being bootlegged. Original artists are not making money. We're putting money into original artists' pockets through this process. And I could go on and on. I think, I've got 1 minute left. I don't know if I'll have chance for a full demo, but if I just wanted to, during the lunch break, Dan and I posted his mashup to the site, and I don't know if it's going to, oops, let's see. I gotta log in again. Well, anyway, I lost my internet connection, so I couldn't connect to the internet. So if you go to legitmix.com and search for Lance, you'll find Daniel's work there. He's decided to give away his mix for free, so you have to buy 3 tracks. So your iTunes library will look a lot cooler after the transaction. So I look forward to your questions. Thank you.
Thank you very much. This has been a very, very enjoyable presentation. I think I would open the floor to questions. Questions, yes, Rita.
I have a question for Eric, in Canadian. In Toronto, in Montreal, it's Eric. When you started negotiating with YouTube, did they bring forth the argument that they are not responsible for the UGC that is carried on?
Well, I was not at all the stages in the discussion, so they may have brought that up. But YouTube is a business, and my understanding is that they want to have a fairly robust framework in order to be a legitimate company and do business and grow a business. They recognize that there is, they think there is music in there that should not be monetized, to use a word that I try not to use because I think it doesn't mean much. But the discussions were mostly about the terms, the how, the price of the license, than such fundamental things.
2921 of the Copyright Act.
No.
I mean, forget about the number. What is taking place is non-infringing, thus I don't have to pay you any dollar or cent.
No, they recognize that they're a commercial entity.
Serious commercial.
They need a license. They were a tough company to negotiate with. We arrived, as I said, to a compromise that is not exactly what we wanted, and I'm sure that it's not exactly what they wanted, but as good compromises, especially for the past, because this agreement is mostly for the present, and the past works. And it provides a good building block for us, especially, to understand better their not their business model, but the way they work on an intimate basis, the kind of music that is available there, and it's an avalanche of music. It's a deluge of music. So we're getting data in order to do a distribution, but also learning what the kind of music, which one is from Canada, which one is from other countries. That is extremely helpful in enabling discussions for the future that have already started.
Question of determining the amount or the terms and conditions.
It was mostly, the terms of the
liability.
license. I don't think there was at any point recently, at least, a discussion about whether or not they needed a license. It was mostly what kind of license, what kind of things would be comfortable for us in an agreement that would not jeopardize whatever case we wanted to make in front of the Copyright Board, because this is one of the things we care about very, very deeply when we enter into those experimental agreements. We do them in order to facilitate the entry of a new business model or a new player into the Canadian market, but we don't want that to be constraining the freedom of the Copyright Board and the courts to decide based on evidence and data what is the fair tariff, the fair rate.
Thank you.
Thanks, Victor.
For Eric, I found what you said fascinating, and I just want to be clear. From what I understood, it's not so much that SOCAN getting this deal with YouTube was unique in the world context, but what was unique was that it was transparent, so that your international homologue, like the other organizations in the world, what are they saying to you? Is Google, Google presumably would prefer to negotiate these deals on a confidential, non-disclosure basis, but they were willing to do it with you not. That part is very, very interesting. Can you tell us more about the reaction?
Well, generally speaking, what we do, here and around the world, is not confidential. Here it's more public because of this copyright board process that is by nature open. But generally speaking, around the world, with some exceptions, mostly in the United States, because ASCAP, BMI, and CSAC are competing under consent decrees. Generally speaking, everybody, the public, the users, know the terms of licensing for TV, radio, shops, etc., etc. When those digital companies arrived to the marketplace about 10 years ago, they sought NDAs, and they got a few societies in Europe to agree. And that became the new normal for most digital services. We don't like it because we represent not only our members, so I answer to my board, who is elected by the 117,000 members of SOCAN, but I also SOCAN represents the millions of other authors, composers, and publishers around the world. So the way I'm able to negotiate here matters to American, French, Germans, Australian authors as well, and we like to be accountable about that, and vice versa. I don't want GEMA in Germany or SASTEM in France to give away the rights of the Canadian members of SOCAN. But as I said, that became the new normal. But here it doesn't work, because if you have to go to the copyright board at some point, you need to lift the veil of confidentiality. So by relying on an agreement that basically is using the commercial TV model to user-generated content to YouTube, it made it very easy to not be shy about its content. It's well known. It's something that the parties agreed could be disseminated. The only thing that we've agreed not to say is how much the license fee is worth. But we believe in transparency, especially at SOCAN. We are very, very big about that. We want to be as transparent as possible towards everybody, mainly towards our members. They are the ones that we represent. We negotiate on their behalf, so they have the right to know everything we do. But we also have a social responsibility, so we want our licensees to know what we're doing, and we want the general public here in Canada to know what we're doing, and also we want our affiliates around the world to know what we're doing. So we don't like this system. But we have to work within the global environment.
Yeah, okay. Sam?
What I'm hoping, this is for Eric, what I'm hoping you can explain to me is why would YouTube be subject to a compensable tariff at all if they're within the meaning of 2.4 subdivision 1 of the Copyright Act? It says they're just providing the means of communication. And if they're doing more than that, wouldn't Bell and Rogers and all the other internet service providers be similarly liable? So I'm just not understanding how you got into this sort of, I think, windfall situation for SOCAN in the first place.
Well, it's not a windfall at all, and it's not a question for me, it's a question for YouTube.
Tanya, am I missing something?
I wish YouTube were here, Sam. I say nothing.
Okay, because I'm not going to ask you.
But I will say this. We have many, many, many tariffs that we pay to SOCAN for various uses on various platforms at various times. I told Eric after I sat back down, I should have said to the audience, you know, if you're worried about clearance, there's an app for that, and SOCAN's already got it figured out. I mean, there's a tariff for everything. So, yeah, I would definitely put the question to YouTube.
So assuming there's compensable, that this is compensable notwithstanding 2.4 subdivision 1, should there be a difference in how you're compensated for a clean, consumable, full version of the Prince song that Mrs. Lenz used, as opposed to sort of just a barely inaudible snippet of it in the background? I'm talking about Universal versus Lenz and that whole incident.
For us, the use of a composition or a song that is in our repertoire is a use. We don't care how the service, the business exposes it to the public. Well, if the music is used, if it's performed publicly, it's licensable. And our task is to measure how many minutes or how many seconds or how many hours of a given track or of a given work has been used, how many times, and then divide the license fee as fairly as possible between our
A use is not compensable under the Section 3.1 Public Performance Act if either A, it does not rise to the threshold level of substantiality, which is written right into the statute. And I would argue that substantiality under the case law is measured qualitatively as well as quantitatively. So I really have problems with that lens example.
But there is a lot of music that rises to this level.
Yeah,
that can be recognized very well.
There is.
And I'm not discounting the practical issues about knowing what is exactly being used on user-generated content sites. It's a daunting task, and we rely a lot on the data that is supplied to us by YouTube in order to do our computation, which is unusual because we usually have the services reporting the use of the music on their airwaves, like TV stations, and we also check with services. We do our own verifications, but YouTube is an animal that is quite new on many levels, including this one. The sheer amount, the ocean of music that is sometimes a few snippets, a few seconds.
Yeah. So the substantiality analysis is A. B is much of it is fair dealing. And C, much of it would come under the user-generated content exception. And it seems to me as if an individual end user posts something on YouTube, they can take advantage of Section 29.21, and there's very, very strong legislative history in Parliament actually referring it to the YouTube exception themselves. So what troubles me about this is when does the public get to comment on the fact that SOCAN is going to gain revenues for uses that are legally not compensable?
I disagree with that. Our legal team disagrees with that, and SOCAN is not getting any revenue. It's the members of SOCAN, the songwriters, the composers, the publishers, who we believe have a right to get a very small portion of the revenues that YouTube is actually able to get from Canada, and we don't understand why this would be different. And we believe very deeply in the level playing field notion. And our other services that are licensed have to find their niche as regards YouTube. So we really think that use of music on YouTube is licensable. It was in the past and will be in the future.
Okay. Thank you for the very robust.
I just want to add to this, though. The exceptions that you're referring to, Sam, you raise a good point. And I don't think, and I've never been of the view, that SOCAN can go in and collect whatever it wants without regard for those exceptions. In fact, those exceptions are raised by users like Bell, like any of the other users all the time in the context of the Copyright Board tariff hearings when we're arguing about what is it worth. And you know, it's up to YouTube to put together their case on how things apply. It's not up to anybody else. But if we're talking about value, I wouldn't think that you'd have a commercial entity. I mean, certainly we'd never say we don't have to pay you anything. Like, we know we have to pay. We just always fight about how much and for what. And I think you'd see downward adjustments. I mean, this is an inaugural agreement. There's no tariff in place yet. The inaugural tariff hearing is going to certainly bring out these provisions, so stay tuned, because often the Copyright Board is a great venue for looking at new legislative interpretations and new law. It's on the cutting edge, for good or for bad, depending on how they come out. But nevertheless, certainly fair dealing is going to be argued. There's certainly an argument there. We argue it every chance we get. It's just sort of how it washes out. But you can't really make those arguments ahead of your agreement. Like, it's sort of like, okay, we know we have to pay you something. Well, yeah, you have to pay us something. Okay, well, and then we go on to our exchanges and we just figure out an amount that we can live with for now. But I think it's a space to stay tuned in, and I didn't want to leave anybody with the impression that users don't make those kind of arguments when we're talking about rights valuations.
I can confirm that they do make those points, and that we analyze very, very carefully what we are trying to license. We're not there to try to grab anything we can. We are very ethically driven and responsible organization. We have our legal analysis, and we have this experimental agreement. But absolutely with you, Tanya, the Copyright Board and maybe the courts will have to to tell us what it is exactly in Canada.
Just to come back to your point on transformativeness or substantiality, like what for me being a software person can Content ID be that line? So if the computers can't detect it, it's not derivative, or it's like coming back to the point here. A lot of those videos, people are just syncing copyrighted music with cats. Like we're not talking about works like Daniel, which Content ID won't even pick up anyway. So I think it most likely was an actual person. If you had to go and rebut, a person said no to you. So it's interesting. I don't think they're even thinking or dealing with Daniel's world. They're just dealing with people syncing entire songs with user-generated video.
Okay. One last question from the floor.
Hi, my name is Elliot Kalmanson. I just have a question actually for Mr. McDonald. I'm just wondering, services like iTunes have become successful in that traditionally, when we wanted to listen to music, we had to buy CDs, and they would be packaged with like a whole bunch of songs. When maybe only want to listen to one, you would get kind of that grouping of all these other songs that you don't want to. I think the technology that you were mentioning is very interesting. I'm just wondering how you think that the marketplace will respond to, as far as I understand, correct me if I'm wrong, you have to buy packaged within the price of that remixed work, all of the underlying songs that make up that. So you have to basically buy a whole library of music just to listen to and own one song, if that's the UGC work that you're interested in?
Well, the earworm example is extreme. Like a 20-song mashup is rare. The bulk of them are two-way mashups or single-source remixes or edits. Mm-hmm. So yes, you would have to buy, if you want to buy, as I mentioned with Sabo's Thriller remix, you got to buy Thriller and then to be able to recreate his remix. So it is a more expensive package. And not everybody buys music, but there's what we want to give remixers is the same opportunity that original artists have, the ability to sell their intellectual property. Not everyone's going to buy it, but we believe there's a big enough market of people who want to support the artists, both remixer and original artists, and who will pay the money. How big? Well, that's where it's started, and that's what we're going to find out.
No, thank you. I just was thinking that because obviously those larger corporations that want to make a movie, or even if they're smaller, but they're willing to invest in the underlying work in order to make sure that everything is clear. But I mean, everyday users, I'm not sure if that's necessarily as feasible in the regular everyday sense. I was just wondering what your thoughts were on that issue, but I do take your point.
Yeah, well, it's interesting. Like our primary market right now are DJs, so DJ to DJ sales. There's a whole culture of DJs making edits, mashups. Well, Daniel went into this, and they get bootlegged, and that's a huge market. There are millions of people which pay for this because they need it for their work. And then beyond that, there'll be prosumers who want to have the coolest different music. Because right now with things like Spotify and all that, music is becoming a commodity. It's on Spotify, it's on RDO. Well, people want something different. And so, well, with Legit Mix, you get something different, but you have to pay for it.
Okay. I mean, how popular is remix, and why don't people just listen to the originals?
That is a great question. I've had that asked to me a few times. To me, the reason I love a remix is that it brings me back to a moment in context of where I am currently. So it makes a song which I really was into 10 years ago fresh again. And so it brings my emotional attachment to that song that I had 10 years ago, but I wouldn't play that song in its original form ever in a party. It has to be contextualized for where it is now. And so that's why remix, it's human expression. People don't want to just listen to the same old stuff. And once music, everyone has the same copy, no, it's not cool anymore. Like it's back in the day, you were cool based on what vinyl you had sitting on or what CDs collection you had. People want to be cool, and that's where remix, there's a whole bunch of interesting cultures. There's a whole culture of people just editing Fleetwood Mac, and in New York City, the coolest parties are just Fleetwood Mac edit parties. Crazy, but that's the way it is.
Only in New York. One point, music has to be more available, more widely available, but I think music should never become a commodity. Availability, ease of access does not equal commodity. I think we have to make sure that the value of music is respected, And I don't think that you meant it the way I understood it, but
Well, in some ways I do. Like you could access
has
all
value,
for sure, but
your
they're
service
doing.
proves it.
But Spotify's doing, or these guys are doing a poor job. I could buy access to the world's music for less than it costs to subscribe to Globe and Mail. To me, that's nuts. How's that possible that musicians got so screwed on that? It blows my mind.
Okay, we'll leave the last word to, please give us your name.
Oh, Barry Sookman from
Barry.
McCarthy's. Eric, I've got a question for you. You mentioned that in your discussions with other performing rights societies that they're asking you about Canada's UGC provision and why we have it. And I was wondering if you could expand on their thoughts about it. And then also, we know that around the world, other countries are looking at other consumer-related exceptions, including Australia, Ireland, and UK, and whether you're hearing from any of your friends in the other performing societies that our exception might become a model that could be implemented in other countries.
Barry, I think if I can use a legal term, I would say they believe it's nuts. It doesn't make sense to us, and it doesn't make sense to me to see a company that belongs to one of the most profitable and valuable corporations in the world that is on its way to reportedly $4 billion a year in commercial revenues and maybe 10 billion. They don't understand why this company should be able to use music for free. We could have had a discussion about user-generated content. What does it mean exactly? It's the fact that people who are not employed by the company upload music, synchronize music, mash up the music with other things. Does it really make it a user-generated content, or are they using one way or another the content that others have created? I think that's the philosophical thing they don't understand, and we should not understand. If we really are serious about protecting our intellectual capital here, if we are willing to make sure that the people who are creating music in Canada, one of the most vibrant markets, SOCAN brings $50 million a year from international societies. If we want them to be able to work here, to develop their businesses here and enhance our cultural values, we need to stop thinking along those lines. Why would YouTube and Google make more money than they already do compared to our songwriters and composers, music publishers? It's not a legal argument. It's not an economic argument. I think it's the kind of society we want to live in. What do we respect? Do we respect stock exchange valuation, or do we respect creative values and hard work?
Just make one comment. The exception actually doesn't apply, arguably, to YouTube. The authorization is the authorization to enable an intermediary to disseminate. There's actually no explicit exception in that particular section.
It's a bit more reasonable, of course, but our view is that those things could be negotiated. There are licenses, there are solutions. Is there any country in the world where YouTube is not able to operate? I mean, for copyright reasons. There are other reasons, political ones, but they found agreements with every rights holders over time without this exception being so broad, so ambiguous, and so complicated than the one we have here. So why fix a situation that doesn't need to be fixed? Why create more uncertainty than the marketplace needs? For us, this exception is not necessary in order to enable those services to operate as well in Canada as they're operating everywhere else.
Okay, thank you very much, and an applause for our speakers.